Hi drivers, Peter LaVoie here. I'm having a conversation with Paul Taylor. We're the attorneys at the Truckers Justice Center. Today we're talking about the federal truth in leasing regulations, which are DOT regulations that govern a commercial motor vehicle lease between an owner-operator and a motor carrier. And those regulations say, number one, there has to be a lease. Number two, it says what terms have to be in the lease. Number three, it says that the parties have to follow the lease. So, Paul, what do you look for in a good truth in leasing case?
One, there's a skim, either under the compensation, for example, the percentages are not passing on fuel surcharge when the lease requires it, or a markup of expenses that, for example, they're marking up their chargebacks for physical damage or bobtail insurance, marking it up in violation of the lease provision. So those are the two most common. We're looking for skimming, either through compensation or through a markup of expenses or a charging back of unauthorized expenses.
Now, when you're doing a consultation with an owner-operator, you're trying to determine if there's a skim, if there's a viable case, what do you need to get started?
First of all, we need a copy of the lease. Their lease, not their brother's lease or their friend's lease, but their lease, ideally. And two, we're looking for 3 or 4 settlements, not 200. Something that lets us size up whether the settlement seems to conform to the lease requirements. And 3, we're looking for proof of a skim, either an invoice from the broker or some sort of invoice from the carrier for a chargeback for insurance that doesn't jibe with what the lease provides. But we're looking for that proof, not interested in bringing a lawsuit on speculation that there might be a skim.
Are there any factors that can ruin one of these cases?
Oh, yes. Primarily, a case gets ruined when we don't have a viable defendant, somebody who can afford to pay our attorney's fees. We work on a contingency, and sometimes the attorney's fees can exceed the amount of the skim, not normally. And somebody who can't pay you if you're the driver who are out there watching, you're an owner-operator, so we need a viable, somebody with 8 trucks and 2 can carry, typically doesn't have the viability, the money to be able to pay, should we be successful in a lawsuit. And the third is we're looking to, at least to start with, drivers who don't owe the carrier money. If you're in the hole because you let the carrier shop do an out-of-frame major for $12,000 and you've been making payments for 2 years, we want to be in a position to prosecute your truth in leasing dispute and not have to defend some sort of chargebacks or amounts that you owe, because you could end up a lawsuit and still owing them money if you're already in the hole with them, and that doesn't allow room for us to recover, or because it doesn't have anything for you to recover.
Thanks, Paul. And again, I'm Peter LaVoie. This is Paul Taylor. We're the Truckers Justice Center. And if you have questions about your lease, you're wondering if you're being skimmed from, or just want to talk about trucking law in general, please give us a call. We're happy to talk to you. Find us on the web at truckersjusticecenter.com.
Be safe out there.